niende kukomboa nchi. Sasa natoa roho yangu niende kukomboa nchi. Sasa natoa roho yangu niende kukomboa nchi. Viva!
Walishikana Shakir, wapagani wameshinda, kumbe badala yake mapambano
yaendelea,
wakashikana baraza mapambano
yaendelea,
tafadhali chukue orderly court ianze. Watu wakae. Watu wakae court ianze. Viva! Go on.
We'll start with the miscellaneous application, miscellaneous 48, 68 of 24. Davis Luchuma. Davis Luchuma. Nick Kirima. Julius Imani Kwapi. Kujeni hapa. Ian Obongo. Hassan Gidinji. Elias Victoria Ochieng. Odhiambo Ojiro. Ademba Alan. Emmanuel Ongua. Morvin James Angoko. Benjamin Mwaura. Stephen Owoko. James Ochieng. Joshua Okayo.
Viva comrades, viva!
Fabian Ochieng. Dayo Ahamo. Philip Onyango. Dalian Muzenu. Cyrus Waweru. Nicholas Karanja. Wayne Ouma. Okia Omtata. Kwa wale nimeita majina, kuna mtu yote hapo chini ya miaka 18. Is there anybody who is under the age of 18 years?
Please the court. I'm Martha Karua, Senior Counsel, appearing with my senior colleague, Senior Counsel Kalonzo Musyoka, Honorable Eugene Wamaro, Honorable, not Honorable, but there was Honorable, but the title is not there yet. Yes, the title is not yet confirmed, but he is indeed Honorable. Simon Boro,
I'm present here.
Simba, John Minor,
I am present, Your Honor.
James Omamo, James Omamo,
Present.
Kelvin Walumbe,
Present, Your Honor.
Senator Manso,
Present, Your Honor.
Ian Motiso,
Present, my lady.
Kabata Mano Hussein.
Manu Amazia, Your Honor.
Permit my poor eyesight. Your Honor, Miss Kabuda Mudama. Anybody else have left? Oh, we have Mr. Victor Kamau appearing on behalf of the Kenya National Commission on Human Rights.
Present, Your Honor.
Anybody? Bob Okumu. Juane Shago. Your Honor, we have a preliminary objection to the charges, but in view of the time, we are wondering whether you could give us a date for the preliminary objection, but in the meantime, we canvass bail. And Your Honor, looking at the charges, you can see it's what one would call omnibus offenses, which the police use when there is not reasonable charge to prefer. Charges merely being used to ask for the holding of the accused persons in custody for 15 days. I've seen an affidavit suggesting that, which is really outrageous. So we'd like to ask, because our submissions on the preliminary objection will be lengthy. The accused persons have already been in custody for more than 24 hours. Because the time they were arrested yesterday and the time they have appeared before you, which is 1:30, they've been in custody for over 24 hours. We would want the court's indulgence that we apply for bail, and you do give us a date for us to come ready for the preliminary objection to these charges. We do believe that the accused persons are before the court for being patriotic Kenyans and for being peaceful, for following the abductees, which is a matter of public knowledge, for staging a peaceful process. So we are saying, in other words, the background to these offenses is a matter of public notoriety, which the court can take judicial notice on, and allow us to go straight to bail application and to kindly give us a date when we can come and make objection to these very outrageous holding charges.
Essentially, what your Honor, senior counsel is inviting the court is to defer the hearing of this application. We want to reiterate that we are appearing for freedom fighters who are fighting to liberate themselves. So, your Honor, the application is that we defer the hearing of this application and we grant bail to the suspects. Of course, Your Honor, I refer you to Article 49, Clause 1, Paragraph H, which provides that an arrested person has the right to be released on bond or bail on reasonable condition, pending a charge or a trial. Pending a charge. That is the basis upon which our application is made. This is not the first application of this nature. They have been made previously, and noting that the application that we shall canvass in the future, if the court is obliged to hear us, they are only proposing petty offenses, misdemeanors. When you look at that, my Honor, as against, again, Article 49, Clause 2, it provides that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by an imprisonment for not more than 6 months. So, Your Honor, our application is well seated in within the four corners of the Constitution. You grant us bail pending the hearing of this application. The application has just been served upon us. The application presupposes to investigate petty offenses and will not prejudice the applicants in whichever manner if the application is granted. We must oblige.
Before the Your Honor, if I may, my name is Manuel Jose. On behalf of the Law Society of Kenya, I want to bring to your attention the constitutional petition number E714 of 2024, wherein Your Honor, Mr. Omtata, who is a respondent in the application so presented in court, is the third interested party. Your Honor, in the said petition, Justice Bahati Momunyi has issued orders that touch the subject matter that is before you, that is the demonstrations and also the abductions. So that, Your Honor, any directions issued before you this morning might be contrary to the Superior Court's directions issued today, this afternoon. As we speak, I thank Senior Counsel Kalonzo Musyoka and Martha Karua were in that court. Your Honor, we supply a copy of the court's directions that were issued yesterday, and we endeavor to supply this court with the directions that were issued this afternoon. So that, Your Honor, any directions that you will give, we seek that they be subject of the directions that have been issued by Superior Court. Perhaps after this 8th, when we appear before that court for further directions. That is our prayer. Let me just start from here also. You know, court proceedings before justice was moved. And you know, I'd like to submit that those orders do not touch on matters before this court. The Honor is mostly of this proceedings in Parliament. The application that is before this court today is merely seeking custodial order against the respondents having been arrested yesterday. The said application supported by an affidavit by one Corporal Anthony Kelly, whereby he is seeking.
Your Honor, my apologies to interject. The prosecution seems to be prosecuting the application. However, Senior Counsel had indicated that we need directions before we get to the substantive hearing of that application. Because the court will kindly give directions on the request by Senior Counsel, and then we are able now to take proper directions in whether the DPP prosecute that application or not.
Unfortunately, I'm cut short. I was making a basis of what is before this court. Your Honor, the application before you is seeking custodial orders for 14 days. Your Honor, if you go by what the senior counsel at the Prosecution, that we directly dwell on the issue of bail, you will have already canvassed this application here. It will have been spent because the application before you is seeking for custodial orders against the 23 respondents, so that the IO can achieve 1, 2, 3 issues score that will enable him to charge the same participant. If we go directly and say that we gave a big release on custody, it will already be, the application will be an academic exercise. So before
In the description, they didn't carry any stones. If anything, I think they chained each other, making it even more difficult for them to move. Peaceful Kenyan demonstrators. And therefore, Your Honor, for anybody to say an affidavit wanting to hold them for 14 days is going against the spirit, the letter and the spirit of Constitution 2010. They are not, nobody, we do not know, nobody is actually saying, because the only reason you can hold Kenyans is if they are, for the kind of period the prosecutor is talking about, is if they are suspected to be terrorists, in which case they would have been arraigned before a court, I think a terrorist court, something in Kiambu. And therefore, Your Honor, we strongly urge that this court protects the right to peaceful demonstration, we believe there's absolutely no reason to hold Kenyans who have been singing peaceful, patriotic songs. That is not an offense. Your Honor, we urge that you come to the help of your country by dismissing this application with the contempt it deserves, because it is unconstitutional, it's even unethical, and it defeats logic.
Your Honor, we don't have a because there are some issues that are coming up, matters of trust and all. I think the court should just give us a direction in regards to whether the matter to proceed or the deferment of the same.
I think, Your Honor, he has already made this application.
Yeah.
Even though I had rejected, he has made his application. We are now responding. So he must hold his peace.
Yeah, no,
We respond, because what else would you have to say other than what is in the affidavit? You've already objected to any application. So let us respond to you. We have something to say. I want to be last. Let my colleagues go now.
Your Honor, I was not done. I was cut short by my colleagues.
Maybe it was
And it can go on record.
My lady, I had the pleasure of appearing in the matter 249/2024. This is the state regarding Boniface Mangi, and I appeared alongside Senior Counsel Martha Kagua. The charges, whether which are being referred in the application, there is a recommendation, a letter which was issued by the ODP in regards to the copy paste. This is this is creating disturbance, which has actually been listed there, and lawful assembly, which has been stated there, and also section 79. And the upshot of this particular letter, which was signed off by the acting director, that was Dorcas Ratgat, consequently, the DPP directs that the evidence presented has not met the evidentiary threshold to warrant approval for the proposed charges. Therefore, the application to actually be, the persons be actually granted bail is actually rightly before this court. The prosecutor meeting, rather trying to prosecute the application in itself, it does not stand in itself.
Your Honor, with your kind permission, my name is Daniel Manzo, representing the team which has been presented before you. Your Honor, Article 49 and 50 are clear as to the rights of an accused person. And one of the rights is right to bail, which will have been issued at the police station, which can be issued by this court. And further to that, all constitutional issues, Your Honor, are already raised in the petition presented before you, and therefore, nothing forbids you from going on to exercise the Constitution and release accused persons on bail pending the hearing of this particular application, which, Your Honor, we submit will be lengthy. We present all the laws dealing with this, and belonging to the senior bar, Your Honor, I'll tell you this happened years before, before 2000, and the responses and the precedence is very clear what happens in this particular sort of thing. In fact, it has not happened, Your Honor, for the last 25 years. And therefore, we want to canvass it conclusively under the new constitution so that all Kenyans, Your Honor, are happy with it, and that the court cannot be rushed into just agreeing with the police officer who sworn an affidavit here, which in the first place is defective, and secondly, discloses no offenses. For there to be a charge sheet, Your Honor, there must be a there must be an offense which is disclosed on the face of the document. I thank you, Your Honor, and agree with my seniors that the accused person be first and foremost be released on bail.
Address the court on the issue of the application amounting to an application really for pretrial detention. Your Honor, I have had the affidavit read to me. It does not disclose what security risk they are not even accused, are going to subject if they are released before that 14 days. They have not really indicated what nature of investigation are pending and which they couldn't have investigated by yesterday. They have not indicated at all with what charges they propose to prefer. So, Your Honor, stripped of everything else, this application is just a sham, farcical, a facade, a hoax, merely intention at keeping the person before you incarcerated. Your Honor, as the Constitutional Commission that protects and promotes human rights, we are exceedingly cautious and apply ex abundante cautela, an abundance of caution before granting any such application. So, Your Honor, we wish to urge this court to actually release the accused person. In fact, not accused person, sorry, I'm mistaken. To release the person before this court, possibly on free bail, because there is even no determination of the felony or misdemeanor they have committed. There is no determination of it. And therefore, you can't even, according to the bail and bond guidelines, you can't really even set proper bail. So, Your Honor, we urge you to err on the side of the Constitution and release the person on a free bail. That is all.
There are a few issues as an officer of the court I think I should bring to the attention of the court as you make your ruling, Your Honor. Yesterday, I went to the Gigiri police station where Okia Omtata was being held. They refused to let me. I was with senior counsel Aminwal, Dewantiru, and several other lawyers and civilians. They refused to let us see him. His brother was present with his medicines. They refused to give access for him to have his blood pressure medication. And later on, they transferred him to Kamukunji, and we were not able to see him, and I know he was not able to access his medicine. I'm bringing this to the attention of the court. One, he's been brought after 24 hours, because he should have been brought early morning, but they have delayed until 24 hours are finished. They held him incommunicado, and it's the same for all the others. I'm informed by my colleague counsels it was the same for all the others. In view of these illegalities and impunity, and the fact that it has already been mentioned that the way the affidavit is, you can clearly see there is no offense disclosed, a sufficient expedition. And if you look at Article 49, it's the rights of the accused, not the wishes of the police. Because this is a wish list they have brought that give us these people for 14 days. It's the rights of the accused or anybody held in custody. So the application is brought under sections that protect the rights of persons arrested, not gives the police the power to continue abusing the law. Article 36, not article, but section 36 of the Criminal Procedure Code also cannot come to their aid. I'm therefore urging you not to even go to consider bail, to just reject this application forthwith and set the gentleman, have I seen any lady there? The gentleman before you at liberty forthwith. And it's a matter of public knowledge that they were peaceful, they were seated, demonstrating, but the police and administration in this country have criminalized legitimate activity. So instead of looking for the abductors and punishing them, they are punishing people who are asking why and where are they. So there is no charge here for us to discuss. Kindly release these persons, set them at liberty forthwith, let the police retrace their steps and come to their aid. Actually, this is an embarrassment and an abuse of the process of the court.
centers around issue of custodial orders that we've been so called investigating officer. Therefore, we direct the state stage to hear and say the application and the rest cases undertaken in the coordinated commissions.
Most of the land.
Most people use it.
We will do this. Mr. Prosecutor, over to you. It's your application. The only thing is that the suspects can sit in their seats, so please do sit where you are. Sit.
Application before this court seeks for custodial orders for the 23 respondents. We have in custody. The 23 were arrested yesterday. In the Nairobi Central Business District and were booked at Central Police Station by building number 60, stroke 30, stroke 12, stroke 24. The owner of the application hearing is supported by judges from by one Corporal Anthony Serena of the DCI. Nairobi Central. Your Honor, in the same notice of motion, that is in paragraph B, and in the supporting affidavit, paragraph 2, the deponent of the said affidavit indicates that he is seeking for the same period as is currently investigating offenses of incitement to violence and disobedience of the law, contrary to section number 96 of the Penal Code. Taking part in unlawful assembly, contrary to section 78(1), as read with section 79 of the Penal Code, and creating disturbance in a manner likely to cause a breach of peace, contrary to section 95(1)(b of the Penal Code. Your Honor, further in paragraph B of the notice of motion, is indicated that the suspects' mobile phones need to be taken to the communication authority for extraction and inform the same are in the custody of the officer. Paragraph E is yet to obtain CCTV footage from the nearby establishment. Paragraph F is yet to record witness statements and finalize the investigation. Most important in paragraph H is indicated that the respondents are threat to peace and stability of the country as they continue to exercise members of the family. Your Honor, it is not in dispute that this court has the ability to grant bail and bond if it is so convinced. But also, Your Honor, said rights can't be limited when the court is given reasons why the same should be denied. Your Honor, I've indicated that these persons were arrested yesterday, and yes, the police issued cash bail, but the reason why the same was not granted to the same person. Your Honor, investigation is yet to be completed. There is a possibility of the two persons of them appearing with the evidence that is for sure that the IO intends to acquire in the 14 days. And Your Honor, the same is as provided by Section 58 of the National Police Service Act. Thereby, it's not automatic that they will be granted upon arrest, especially when there's a threat or there's a continuance of committing of the state offense. Your Honor, they have been told the state suspects were produced or availed in court within the requisite time of 24 hours provided in the Constitution. Your Honor, unfortunately, there are some other ongoing, other proceedings, counsels have confirmed in the High Court. And that the application before this court is proper. First one to Section 36A, the CPC, whereby an officer having arrested suspect has to produce them in court within 24 hours. And if there is need for the officer to require more time, the same should be done in writing and presented before court with the results. Your Honor, the same writing and the results are contained in the application before this court. Your Honor, if by any chance the court is inclined otherwise, and is not convinced by the application that is before it, we pray for stringent conditions as provided for by Section 36A, precisely Section paragraph 4, Section 36, subsection 4, B1. And also subsection 36A, subsection 5, subsection A. Your Honor, no two incidences or two cases for any particular court are similar in nature and in fact. And if that was so, the two usually are usually considered for consolidation. Your Honor, there is no other pending matter before court pertaining to the application that is before this court today. There are exceptional circumstances that warrant custodial orders to be granted. And Your Honor, I've had counsels trying to trivialize this issue, but these are not serious serious matters. Matters touching on peace and the breach of that circle is serious matters. So it is our submission that we hope that the court considers what is before you and the reasons and submissions of the prosecution. And if the court is inclined or has any questions further, the RU is in court and can also assist the court in getting to a determination whether the application that is in court is serious. That will be all.
Your Honor, we thank you for that guidance. We reiterate the argument we put before. And really, can anybody in this country believe that the investigating officer would want 14 days custodial sentence to investigate a Kenyan who is suspected to have behaved in a manner likely to cause a breach of the peace? These are the things we were running away from, Your Honor, when we enacted Constitution 2010. I have to agree with my learned brother here who described this application in its truest form as incompetent, use of the court process, even if, and I believe they took all the telephones by the gentleman before you, they can continue and hack them. That does not require 14 days, hacking them. If there's any offense disclosed, then they can revert. But Your Honor, the Constitution is supreme. The subsidiary legislations and criminal procedure code, to which reference is made by the prosecution, are all subject to the Constitution. Nobody can argue against the right under Article 37 to rightful. Kenyans have a right to demonstrate, to picket, to petition whoever in a peaceful manner, Your Honor. And the only proviso is unarmed. These people are chained to each other. As I said, I reiterated the earlier argument. Therefore, we urge that you release these peaceful Kenyans unconditionally to go and join the rest of the Kenyans as they welcome the new year.
According to Omtata,
Allow me to go straight away to the supporting affidavit. Because if the supporting affidavit does not support the holding of these Kenyans, distinguished Kenyans, then there's nothing more. The court has just to discharge them. There's nothing like issue stringent conditions. On what? There are no charges before you. Just a request for the police to spend New Year with them, and they are not their relatives. They are not their relatives. They've already doing other things. So once you find that this affidavit that I'm about to persuade you discloses no offense, because you're being told they were about to commit offenses against the peace, then Corporal Anthony Kerini, he states the first and second paragraph is, the first paragraph he says is competent to swear the affidavit. The second one, I'm investigating offenses of incitement to violence, disobedience of the law, contrary to section 96 of the Penal Code, taking part in unlawful assembly, contrary to section 78(1), as read with section 79 of the Penal Code, creating disturbance in a manner likely to cause a breach of peace, contrary to section 95 of the Penal Code. Then he goes on, so he's investigating, he's not sure, because if he was, he would be saying they committed that was a crime. Then he says the mobile phones have been taken away. He's disclosing that the police have actually violated the law. They cannot take their mobile phones without a court order. Because in the first place, they are not under investigation for any offense. The police are saying largely they are investigating offenses. They are not accusing any one of them of committing that offense. They are merely under investigation. So they've already deprived them of property contrary to the Constitution. Then they say they are looking for CCTV footage, paragraph 5, near Java and neighbor supermarkets. I think this is now meant to make our imagination work and think that Java and neighbors were under threat. We are not told these two establishments are suspects, and there is no offense in being near them. They are looking for customers daily. And if they were near them, then they were potential customers, not a threat. Then they are saying they are here to obtain CCTV footage. 24 hours, more than 24 hours have elapsed. If they were serious, they would already have had the CCTV footage and they would already know if an offense was committed. They are talking of witnesses are yet to record. Which witness? This type of offenses, it's only police who are the witnesses. If police have not recorded their statements or come forward, then there is no evidence unless if they are saying, give us time to cook. The respondents, if released, may continue to disrupt peace and tranquility. We have not even been told that they have disrupted peace. He is just saying he is investigating offenses. So which peace and tranquility will they disrupt? In fact, it is police who, before the national television and media, disrupted peace and security by throwing tear gas on armless people, mistreating them, dragging them on the streets while making arrests. Your Honor, we've asked you to take judicial notice of these events, which were widely publicized in the media. A request. They are also complaining of that they will continue to incite on social media platforms. I'll confirm that I follow some of these gentlemen arraigned here. And I have not seen anything as a member of public, and I am sure no member of public has complained that they have incited. These are just a wild, fishing expedition. Let me not call it a name we were once called by a court of law, unethical. So let me just say that it's a fishing expedition. It should not be allowed, and this affidavit does not even disclose anything worthy of investigation. We are therefore urging you to release these patriotic Kenyans who left their work to pressure for the release of abductees. And they are actually carrying out their duty in the Constitution to uphold and defend the Constitution when they are asking for the release of others. Your Honor, it's the courts of law that arbitrate when there's a conflict between those in authority and citizens. It's a straightforward matter. Just set them at liberty. Let the police go and reread the Constitution of Kenya. Let the administration, the current administration, reread the Constitution of Kenya. It doesn't say anywhere that when those in authority are not pleased by the questions Kenyans are asking, Kenyans have to be incarcerated. Allow us to all go and make our preparations for the new year by releasing this gentleman. And before I sit, I would like to bring to your attention that Honorable Omtata was injured in the course of arrest. He has a painful and swollen shoulder. Apart from being denied access to his blood pressure medicine, he needs to see a doctor now. It should have been yesterday, but now will be good. So we urge that they all be released and let our lives all go back to normal. And it does appear that he's not the only one. I can see a swollen hand there, Your Honor. And all of them actually need medical attention. And his chest was stamped on. So all of them need medical attention. I had already indicated they were manhandled, they were dragged on the street, they were kicked. They need medical attention now.
Your Honor, if I may, on behalf of the 23rd respondent, we have a proceeding which we are following.
Your Honor, allow me to rise and oppose this application and consider the same as a hopeless one that does not deserve the ink and the paper it's written on. Your Honor, the application is inviting you to limit the rights under Article 37. It has become a practice and the culture of the prosecution and the police when they want to suppress individuals who are fighting for freedom, like these freedom fighters, to bring such kind of applications. At the fullness of time, Your Honor, when considering this application, you might have to ask yourself, if the police finds that the suspects committed no offense, what shall follow therein after, if we incarcerate them for 14 days? Who shall be held responsible for that breach? You might also want to consider, Your Honor, whether the facts pleaded in these affidavits and on the face of the application convinces you to admit the application. For example, you are being told, Your Honor, that you incarcerate them because the police want to investigate the content of their funds, which they unlawfully confiscated. One, they admit that they have the funds, and therefore they're not in custody of the suspects. How will the incarceration assist the police to achieve the provisions or what is pleaded under paragraph 4 of the affidavit? Number 2, Your Honor, paragraph 5 tells you that you need to incarcerate them so that the police can investigate the CCTV footages for a nearby Java and Naivas supermarket. Are they in control of the suspects? Are they within the reach of the suspects? Will the suspects inhibit the police investigations and or access to those purported CCTVs? Therefore, if the answer to the court is to admit the application, how will that assist the police? Noting that our clients are not in possession of those CCTVs. They do not even know them. Their location is not even specifically pleaded. We are told they are near Java. Which Java? Near Naivas supermarket. Which Naivas supermarket? And there are several. And who is in the custody of these CCTVs? Are they private CCTVs? Are they public CCTVs? And how will the suspects interfere with that process? Number 6, Your Honor, paragraph 6 tells you that they need to record witness statements. This action complained of happened in the glare of the public on the streets of Nairobi. People were coming from Kayole, Mathare, Kileleshwa, and all over some of them even came from Kirinyaga like myself, and I witnessed. So which witness is this? Who is supposed to record? We are 56 million Kenyans. We all witness this. Are we all possible witnesses before you that you all need to record statements? If that's so, Your Honor, I am ready to do one. Number 7, Your Honor, is even more ridiculous and annoying. You're being told to incarcerate them because, and I want to read in verbatim, that the respondents, if released, may continue to disrupt peace and tranquility. You incarcerate them on speculative and on mere speculation that they can interfere. These guys are being told, Your Honor, that incarcerate them because they may. Yani hawa watu wanaweza. You understand, Your Honor, the content of the contempt this application needs to be looked at? That is a contempt. That's on mere speculation, you incarcerate them. Number 8, Your Honor, paragraph 8, the respondents are a threat to peace and stability of the country as it continues incite. If the police has evidence of continuous incitements, why have they not charged them on those previous alleged incitements? Members of the public via social media platforms, if released, therefore, they will cause disharmony in the country. Disharmony in the country. You know, what disharmony? The country is already in disharmony. And the mere fact that we have come here to defend these freedom fighters indicates and signifies the discontentment Kenyans have. So this complainant that his country has been disharmonized, Ninadi ana complain. So Your Honor, you're being told at paragraph 9 that for interest of justice, I pray that this honorable court to grant 14 days. 14 days, Your Honor, to investigate speculations, 14 days to investigate content that are not within the possession of our clients. Your Honor, as I sum up, I want to invite you to have a look at the judgment in the case of, in the miscellaneous application E014 of 23, Haji versus Republic. Of most interest is paragraph 10 of that judgment. The judge in that case said, the presumption of innocence also means that the pretrial detention should not constitute punishment. Because at the fullness of time, the event that the police reaches a conclusion that is not, our clients are not culpable, they have already have suffered 14 days incarceration. Finally, Your Honor, this is a hopeless application. In the event you find it worth not to dismiss the application, admit them on bail. The prosecution has already admitted that fact and even proposed stringent measures be proposed as against our clients. That's an admission already. So there is no opposition of our bail. It came from the prosecution. It's on record. So in the event, Your Honor, you consider it worth to admit the application and consider the proposal by the prosecution, admit them on free bond. Consider these individuals as freedom fighters. People who are fighting to liberate themselves from bad governance, from a government that does not want to be called to account, from a government that has transgressed over our constitution, from a government that listens not, from a government that has gone wrong. I invite Mr. Mburu to submit.
I associate myself, my name is Simon Mburu. I associate myself with the submissions of counsel. And I wish to point out one very interesting thing with the affidavit supporting the application. And I'd wish to invite the court to look at paragraph G and H of that affidavit, which presume that the respondents
are guilty of breach or disrupting peace, and they are guilty or are a threat to peace and stability of this country. I will invite the court to look at the provisions of Article 50, sub-article 2A, which provides that every accused person has a right to a fair trial, and that right includes a right to be presumed innocent until the contrary is proved. The gist of the affidavit before you has already found that if indeed the respondents are admitted or are released, they will continue to be a threat to peace. That's a finding, and that directly violates the presumption of innocence in respect to the respondents before you. The other issue I would wish to submit on that presumption is that the investigations that tend to be conducted are already prejudiced. In that respect, the investigating officer has already summed up and made up his mind, and the outcome is predetermined. That also goes to root of Article 50, sub-article 2A. Your Honor, further to that, the affidavit seeks an omnibus incarceration of 14 days for all the accused, or for all the respondents before the court. And I will agree with the prosecution when it says that each case before the court is not the same. Therefore, there are factors that are different in respect to each respondent before this court. But the timeline sought by the prosecution is the same for all of them. It has not distinguished or given reasons in the affidavit why it needs 14 days for the first respondent, 14 days for the second respondent, and which factors have informed them that the 14 days are sufficient to conduct investigations in respect to all of them. Therefore, that omnibus seeking time for detention for all of them violates equal protection and treatment of the law that these respondents to enjoy. You know, it's also, and I think Council had touched on it, but I wish to highlight from the affidavit. The prosecution seeks to conduct investigations in independent institutions like the Communications Authority of Kenya. It also needs to extract WhatsApp and Facebook and X messages from the phones of the respondents. But what is the nexus between the action to be taken by the investigating officer and the respondents before you? That is not within this affidavit. It has not been adduced, and for that reason alone, the invitation to detain them for 14 days cannot be granted. Lastly, Your Honor, you are told that there is threat to interfere with the investigations. I submit that I have gone through this entire affidavit. Not a single paragraph of this affidavit speaks to the issue of interference with the investigation. Therefore, my submissions on that point are that those are submissions from the bar by the prosecution. If the investigating officer was not able to identify that such interference was possible, then I do not know on what ground the prosecution would make such submissions that they are interference.
Lastly, Your Honor, you have not been supplied with a holding charge. The law is very clear that when the prosecution makes such kind of an application, then it should also draft a holding charge that identifies the offenses that the respondents before it have committed. That is not before you. And for that reason, I wish to urge the court to decline the application to have them detained for 14 days and urge the court to find that no compelling reasons have been adduced by the prosecution that would warrant the grant of such release. As I conclude, Your Honor, there was an issue about some of the respondents, and more particularly, the second and 15th respondents who are attacked by the OCS Central Police Station. There is also denial of medication or access to medical attention. That was in respect to the 1st, 3rd, 11th, and 23rd respondent. There was also denial of right to counsel for all the respondents. Your Honor, in the circumstances, we would wish to have summons issued to the OCS Central Police Station by the name Samson Talam to come and answer before this court why the constitutional rights granted to the respondents were denied. It's very painful that one of the respondents here is holding a constitution of Kenya, and the allegation against him is that he is guilty of a breach of peace. Therefore, I would wish, as I conclude, Your Honor, that summons be issued to that particular officer. The name is Samson Talam. And if you would look at them, and I think their testimony, you can see this is one of them, the clothes. There is also this one. So those are some of the issues that we wish the OCS to address. I conclude at that.
With a lot of humility, allow me to have the Law Society of Kenya go on record. My name is Kabata. I am the Vice President of the Law Society. My good senior has been sitting impatiently. I will allow him to take the first strike before I...
Thank you, Your Honor. Your Honor, I would like to refer to the sections of the law in relation to the reason of the request. That is Section 78 of the Penal Code, 96 of the Penal Code, which works together with the Public Order Act of 1956. And the regulations thereunder indicate that and agree with the Constitution and Article 7 that Kenyans can demonstrate. But in the event a demonstration becomes what the Prosecution is requesting, first and foremost, an officer to the level of an inspector of police must then give a proclamation. It is in the same law, and allow Kenyans to disperse loudly and clear with a loud machinery, and give them about 15 minutes to disperse. Now, only in the event that doesn't happen, then other consequences may follow. And that did not happen in this particular case. And Your Honor, looking at the affidavit and the Constitution as it is, Your Honor, some people may argue that this court does not interpret the Constitution. And this court deals with constitutional issues all the time. That Article 49 and 50 do apply. Your Honor, I plead with you to find that the application did not warrant a merit, and therefore it should be dismissed. And if you do not find that dissent, then Your Honor, you could release, the Constitution allows you to release them on free bail or on bail as requested, so that they could avail themselves for this investigation. I thank you, Your Honor, and plead with you to release them this person.
On behalf of the Law Society, we will be assisting the court to look at the law. And I know many of our colleagues here will also be permitted to address the court on these issues. I will focus more on the law and agree entirely with what has been submitted in opposition to this application. First and foremost, Your Honor, my good brother from the DPP is being given a task that is akin to a mortician. It is a very dirty task, but he must do it nonetheless. This procedure has been found to be constitutionally offensive in many instances. I will highlight the cases so that the court can digest the veracity of the legal issues that have been canvassed in these authorities. The first authority, Your Honor, is Michael Rotich versus Republic, 2016 EKLR. Your good elder brother, now in the Court of Appeal, Luka Kimaru, expressed himself as to the constitutional improperness of applications to continue detaining persons, especially without a formal draft charge, to inform them of the offenses that they will be charged with. In fact, your brother Kimaru went ahead to state that the reason why the Constitution states to be informed of the reason for the detention continued. Once you are arrested, you have been detained, but the continuing of the detention then, as is presently in this application, can only be met with the presentation of a holding charge. At the very minimum, he emphasized. Your other elder brother, Professor Joel Lugubu, in the now famous Oscar Sudi case, went ahead to expand what Article 49 requires a court to do. He says, in that case, paragraph 24, that first, the state must persuade the court that it is acting in absolute good faith. I will not dare to ask anyone to raise their hands if they believe there is good faith here today. But if I did, Your Honor, you will realize that even the journalists with us here today will not believe that the state is acting in good faith. Secondly, that the state must demonstrate that the continued detention of the individuals without charge is the least restrictive action. And the balancing aspect here is on fourfold. One is on the rights of the arrested individuals. The public interest, order and security. Number three is the need to preserve the integrity of the administration of justice. And lastly is the interest of victims of crime where appropriate. This will not apply in this present case. He emphasizes that while balancing all four, a court must act to aggrandize and not diminish the rights of personal liberties of arrested individuals in line with the other interests. Finally, the same judge, Justice Professor Ngugi, in Joseph Diongo and 17 others, cited with acclamation, 2017 EPLR, in custody of suspect, under subsection less, it lists 4 grounds. Says, there are compelling reasons for believing that the suspects shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. I am reading fast because I know the court has this record. It is necessary to keep the suspect in custody for his own protection, where the suspect is a minor for his welfare, but the suspect is serving a custodial sentence, or the suspect having been arrested in relation to the commission of an offense has breached that condition. They are not to be read in isolation, so that the court can appreciate the drafting of this section. The averments that they will continue to breach the peace are conclusive without trial. They need to be tested in trial. And while we are finalizing, we wish to express to the court that the Law Society of Kenya and other well-wishing non-governmental organizations have been able to secure fundamental progresses in constitutional interpretation in Kenya, significantly that touch on the rights of persons to assembly, to picket, and to demonstrate. One of these includes to have members of the National Police Service identify themselves while undertaking or rather engaging with peaceful protesters. 2, we also managed to get an order that the members of the National Police Service, while engaging with lawful and peaceful demonstrators, should not use weapons that will permanently leave marks on victims such as the ones before you, and also not use noxious substances including gas or chemical-laced water. Your Honor, I want to tell you in particular that none of these orders has been complied with by the National Police Service. Why I started by saying that my colleague and my very good colleague from the DPP is doing a task almost akin to a mortician is because that application is sworn by a member of the National Police Service, a perennial continuum. Whereas today in the morning, Your Honor, we appeared before your 2 elder brothers in the High Court, Justice Mamuya and Justice Uteti. The 2 of them observed in particular that in petition E714 of 2024, the 3rd interested party, Mr. Andrew Omtata, Senator of Busia County, was missing. There was an order for his physical attendance and his compliance with directions, particularly at Part 4. By close of business today, what you're being invited to do, and I would pray that it applies to all the respondents hearing, is not to continue, in fact, to violate the orders of the said court, extend the latitude that Mr. Omtata enjoys to the other respondents, and dismiss the application forthwith, release the said respondents, and allow us to personally commence malicious prosecutions against the said officer, together with the others who have been mentioned before court, Your Honor, because sooner or later we must live in a country that is governed by law and not governed by individual fear. Before I forget, Your Honor, this year, the judiciary has been the subject of the branch that the police, the National Police Service, has to offer in its ill-mannered your sister at Makadara, Honorable Kivuti, God rest her soul, was gunned down by members of the National Police Service. And to date, I have not seen the Inspector General issue an apology to Kenyans or even the judiciary. And these are the same people that are swearing these affidavits. I have transcended from contemners to murderers. I now wish to allow my colleague, Mr. Felix, to sum up.
Thank you very much, Your Honor. For the record, my name is Felix Keaton. And Your Honor, is to submit on two issues. First, Your Honor, is whether the motion application before you is merited. And secondly, Your Honor, is whether there are compelling reasons to further continue detain the respondents. In such a motion application, Your Honor, it should be within the square with the parameters of section 36A. And we humbly submit, Your Honor, that section 36A of the Civil Procedure Code places two-tier test in such a motion application. The first tier test, Your Honor, is with the investigation, and the second tier test rests with the Honorable Court. On the first tier test, Your Honor, the prosecution, the investigation, and that is, permit me, Your Honor, to refer you to section 36A, paragraph C, whereby such an application should contain the general inquiries that have been made by the police in relation to the offense and any further inquiries proposed to be made by the police. And in such, Your Honor, the question that begs our attention is whether there are other proposed inquiries to be made before you. And in such, Your Honor, we humbly beg to refer you to paragraphs 4, 5, and 6 of the supporting affidavit of Anthony Kerini, whereby he states, Your Honor, that they intend to subject the mobile phones of the suspect to Communications Authority and to extract WhatsApp, Facebook, X messages, and photographs taken from the respondents. We humbly submit, Your Honor, that such an exercise can be undertaken when the respondents have already been released. The second reason, Your Honor, that you have been told is that they are yet to obtain CCTV footage from the nearby Java. We still submit, Your Honor, that such an exercise of extracting any slides or any CCTV footages can be done when the respondents are being released on bond and or bail. And the final reasons that you've been tendered, that they have tendered, Your Honor, they have given, is that they undertake to record witness statements. We submit, Your Honor, that any recording of witness statement, either under inquiry or charge and caution, can be done when the respondents are out. It need not be undertaken when the respondents are in custody. Your Honor, the other second tier, that is an obligation placed on the Honorable Court. And permit me, Your Honor, to refer you to section 36A 5, that is clause 5, whereby the court shall not make an order for the remand in custody of a suspect under section 1 unless there are compelling reasons for believing that the suspect shall not appear for trial. And secondly, Your Honor, is that it is necessary to keep the suspect in custody for his protection, and that the suspect is serving custodial sentence. Your Honor, it's our humble submission that no such reasons has been tendered before you, Your Honor, that there are compelling reasons that the respondents will not appear before you, or that it's necessary to keep them in custody for their own protection. There is no such ground. And I said, Your Honor, we humbly submit that the motion application before you is bereft of substance and the statutory blessings under section 36A of the CPC. And having submitted so, Your Honor, we conversely, inversely submit that there are compelling reasons to release the respondents on bond and or bail. And we invite you, Your Honor, to consider certain factors. First, Your Honor, is that the respondents they have a fixed abode within the Republic of Kenya. That has not been disputed. Secondly, Your Honor, we invite you to consider the primary purpose of bond and bail. That is to secure the attendance of the accused person as and when required by judicial court. And as such, Your Honor, we submit that the respondents before you shall attend judicial court as and when required. And also to further buttress, Your Honor, this point, will invite you to determine what amounts to compelling reasons that the same has been settled in the case of Republic vs. Danford Kabage, whereby Judge Mativo stated succinctly that compelling reasons that the prosecution should place material information before the local court to demonstrate the compelling reasons. And as such, Your Honor, we submit that within the ambit of the law, the motion application before you is bereft of substance and merit and legality. And we humbly invite you, Your Honor, to consider also Article 49(1)(h) of the Constitution, that an arrested person has a right to be released on bond and or bail on reasonable conditions, unless there are compelling reasons. And having submitted that there are no compelling reasons, we humbly invite you, Your Honor, to proceed and to strike for the rule of law and to unleash your sword of Damosin and to release the respondents on bond and or bail. And we humbly propose, Your Honor, that free bond should be sufficient to secure their attendance in the court. Reason being, Your Honor, the freedom songs rings loudly, Your Honor, that hatuna bunduki, hatuna rungu. They are just harmless people fighting for the rights of the Republic of Kenya. And as such, Your Honor, we humbly invite you to release them on bond and on bail in order to nourish and flourish the tree of freedom and liberty. We so submit, Your Honor.
That will add the submission for the respondents.
Your Honor, I do apologize for coming late. I did not know that the proceedings were on. Until my secretary pointed out to me that accidentally he has come to know that the case is on. There are only two things I wish to say to Your Honor. We administer justice in fairness, equity, and when we come to court, we must come to court with hands. What is happening to the senator is despicable, deplorable, reflects a banana republic at its worst. Your Honor, Mr. Ndegwa, my friend Mr. Ndegwa and myself spent about 4 hours at the office of the OCPD in Nairobi. One, we just wanted to see Senator Omtata at his camp he was denied that everything, although he was at the police. Secondly, Your Honor, the senator is a sick man, and his brother had the medicine. I saw the medicine with my own eyes. We wanted to make sure that he continued to be alive and in good health. We pleaded with the police, senior police officer was in many, many hours. I had even the opportunity to address our learned media on what is going on. He was denied medicine and facility. Your Honor, the senior police officer must have been acting on instructions from legal advisors. He must have been acting on advice from the senior police officer. Your Honor, for them now to come with this document, which I've just seen here, and ask for such an order, I'm asking you very respectfully, rise to the occasion and say to them, no, that will not be the position in Kenya, where you are deny a client an advocate his right to your counsel under the Constitution, where you deny a client or a suspect medicine as required by the Constitution. There are very clear provisions in the Constitution. One of them, if I may borrow the word, says that a person shall not be denied medicine or treatment at all. He was. Your Honor, we have had enough of this, of what is going on in the country. No wonder that the Kenyans are now filing a petition at the Hague of the position that the country finds itself. Rise to the occasion and show the people outside that there is still rule of law in the country. That we are not yet a banana republic. That's all, Your Honor. Reject what the DPP has said. It's a disaster. That's not what we fought for. That's not what the founding fathers fought for. It's disgraceful, and to embarrass people like ourselves have had to run so many within a short time to be here. In doing so, I must at my age of 88 to ensure that we have a rule of law in the country. Thank you.
Well, maybe senior counsel can sum up for the respondents and then we get some issues from the UBP says there's nothing to respond.
I will start on that statement. I have something of importance for us. Let not counsel speak for me. Your Honor, an allegation was made here by counsel Zebra, but I did admit that the persons before should be allowed bail. That is not the position. Let me put it, and I repeat myself and reiterate so that counsel can have it properly. I said in the unlikely event that this court will not grant us the fair sort of subject. That's stringent measure to be taken. And in plain English, by bad luck, this court finds a new
In the post, Your Honor, could you imply that the Honorable Court in discretion is a bad luck?
No, I was just translating in plain English. Further to that, there was another issue that probably could address, the issue in regards to mobile phones. Your Honor, the procedure for extraction and application must be brought before court. The same has been made known to this court that there is a need for the same information to be extracted, and that is the direction of this court. we have not yet extracted because even the timelines do not allow us to suggest the same forensic examination. Your Honor, the main issue in regards to why the officer is seeking custodial orders for the state suspect is that the normal investigation completed due to the short nature and the provisions of our Constitution that the arrested persons must be released within 24 hours. Some aspects of the investigations can proceed while the persons in court are out on bond, but some cannot take place when they are outside. Your Honor, we request this court to grant us the order as we, from the application,
It's clear. Your Honor, counsel is supposed to respond on pure points of law, not facts. So you need to limit yourself to the law.
I'm just
But you cannot
I'm
interpret facts.
responding to an issue that was brought up.
No, but you have to limit yourself to the issues of law. That's the response.
Yes, that's all. Kindly let me proceed. Otherwise, you will be getting at the end. We are actually consuming a lot of process. Your Honor, what is before me is an application seeking precisely what is provided for under the law. Section 26 says, I quote it, Your Honor, where the compelling reasons for believing suspects shall not appear for trial, or may appear with witnesses. Your Honor, the said is retaliated in the application. We have shown that there is continuous excitement of the member of the public. Section, the said section also provides that unconditional release cannot be, suspect can also be detained longer to allow the IO or the officers to conduct investigation. Your Honor, finally,
I'm just going that the approach taken is a bit malicious because he's not citing the law in totality. He's reading apart. Anyway,
okay, section 36A. For
subsection, I am at that particular section.
Subsection.
Perhaps more importantly, Your Honor, with your permission, if I may raise my name, the issue I have with the response is that the counsel is misleading the court. When he says that there are issues of interference in the affidavit, that has not been declared in that affidavit. That is not in the affidavit. There is no possibility of interference when that has not been deponed by the officer doing the investigation. So on that point alone, then it cannot be said, it cannot be misleading the court. That is the risk of when counsel goes on a fishing expedition and fails to confine himself to a response on points of law. Counsel address points of law.
Your Honor, what I was indicating to the court, probably my language might not be palatable to practice. Maybe let me take out the interference.
But that's a point of fact. How shall we respond, counsel? We are not on our feet. But you cannot raise new issues.
So as I was informing this court, where there is a likelihood to commit an offense or continuance of the offense, and the same is indicated in the application by the officer. And if I would be precise, I think counsel has taken that is in paragraph number of the affidavit. Paragraph 7. That is The respondents, if released, may continue to disrupt peace and tranquility. Your Honor, let me take you. You've told me to read it, and I've read it.
You know, the risk that the council is inviting us to is when you allow him to regurgitate the facts. If he does not have anything to say, you see, we'll just take this.
So, Your Honor, I'm just saying. That was something that the detention of the said person before court. There is a likelihood of continuous committing of the offense, and the same we urge the court to allow this application in its totality, seeking for the 14 days. I think I've responded to all those issues that have been raised. Oh, the final issue that has been brought on issues of the breach of certain violations of the Prosecution. There's a proper forum for the same. Constitutional court, where they say the applicants, whether they were denied counsel, presentation, and all, can be dealt with and canvassed properly. That will be.
Your Honor, there is an issue he has brought up, just one issue, saying that this court can grant the order for the phones, for information to be extracted by the phones. This court cannot. And I urge you to look at the notice of motion. It has only one prayer: to detain them. They have assumed they have the right to rummage through the property of the gentleman on the dock. So that is not a prayer you can grant. It's not asked for.
One word, Your Honor.
The Senator free, and you can give the people. Thank you very much. Set them free. Yeah, we are dealing with a country that does not respect at all. No respect to the Constitution. And the prosecutor does not uphold the rules to respect.
I need to happy new year. I just noted that the gentleman with the torn shirt was actually abducted this year. I don't know whether anyone can remember. He was abducted for about 5 days. I thought the court was mindful. This may be just another way to abduct him.
In fact, the senator was abducted, but now it has been turned into a legal thing. But at the beginning, he was actually abducted. They were all abducted.
respondents were before this court, detained for 14 days to enable their applicant, that is the DCI sent to Nairobi to complete investigation. They have relied on the grounds on the face of the application, together with the supporting affidavit, sworn by Corporal Anthony Kerini. In brief, they state that the 33 respondents were arrested in Nairobi CBD and that they were booked by Central Police Station, that an OB was provided for the same, that the mobile phones of the state suspects were taken, and that are to be subjected to Communications Authority of Kenya, that they are to extract messages, WhatsApp messages, Facebook, X messages, photo statements that are inciting to members of the public against the state. That they are yet to obtain CCTV footage, record witness statements, and that in the end, should they be released and continue to disrupt peace and tranquility within the country, and that they are a threat of peace and stability. We had many counsel appearing for the respondents. They have given their response. Among them, they have quoted sections of the Constitution on the rights of the accused person. They have also raised the issue on conditions of the accused persons who have been availed before this court. They have also stated the law on what is to be considered for the grant of bonds, which is compelling reasons for the court to consider. They have raised the rights of an accused person to picket and to hold a peaceful demonstration. They have also raised an issue that the affidavit that is before court does not disclose any offense, but they are mere speculations. That the investigations to be carried out will not require the presence of the accused person, and that the court has the discretion to grant both bail and bond to the accused person, and that the same has not been objected to. That the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged. That the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation. That the same is arbitrary and an abuse of the court process. That the investigations are already prejudiced, that court orders were not obtained to extract information from the said phones belonging to the respondents, and that the court has to balance the rights of the accused person while looking at the said application. In my analysis and having heard all the submissions that have been made by the prosecution and the defense, I have considered the law, the issues that have been raised. I have also considered the nature of the offenses that have been stated in the said affidavits. I will agree with the defense that the same are misdemeanors. I have also looked at the said application and the number of days that is being asked for, which is 14 days. The prosecution, in stating, making a request for the said date, has also stated that there are some aspects of the investigations that will not require the presence of the respondents before this court. This has been raised by the respondents' counsel. The issue of the CCTV cameras, recording of witness statements, will not require the presence of the accused persons in custody. More particularly, what has been stated was that the accused person are a threat to breach of peace. Therefore, from the evidence, from the material that has been placed before me, and the law, looking at the compelling reasons. The court has looked at what has been submitted and agree with the defense that the court has to balance the rights of the accused person while granting the orders that has been sought. In considering the nature of the cases that the IO wishes to investigate, the court also considered Article 29 of the Constitution, which provides for the rights and freedom of the accused person. It states that every person has the right to freedom and security of person, which includes the right not to be deprived of freedom arbitrarily or without just cause. The same should be done without, if the same is done without trial, the same should not be done without trial except during a state of emergency, in which case detention will be subject to Article 58. Article 24 of the state constitution also on the rights and fundamental freedom on the Bill of Rights shall not be limited except by law. Therefore, in my analysis, so far as the bond and bail is concerned, there must be compelling reasons not to grant the same. The court board promotes values that underlie the open and democratic society based on human dignity and equality, equity and freedom. It therefore follows that the function of bail is to ensure presence of accused person to attend the trial. Be as it may, the nature of the offences as stated does not disclose or warrant detention of the respondents. The state have failed to prove that the investigation will call for limitation of respondents' liberty and require them to facilitate or conduct investigations. However, I would wish to point out that justice demands thorough investigation, and at the end of the day, if investigations reveal that the respondents are not culpable, justice will have been served, and the course of justice therefore will not be a smooth ride. And based on that, I will allow that I'll make the following orders: that the 23 respondents hearing would be released on bond. I hereby grant them a bond of Kenya shillings 50,000 with a surety of similar amount, each one of them. 5,000. I will also direct that they report to the investigating board. Pending investigations, we'll mention the case after 14 days.
So they're being released on a bail of 50K and a surety of the same amount. Right there, they're being released on a bond of 50K. Quite unfair. You will reappear in court in the next 14 days. Your Honor, tremendous respect. We appreciate the ruling of the court. And before Senior Counsel say anything, I just want to point out one thing. Your Honor, it is the 31st of December 2024, meaning that tomorrow will be a new year. Just on that basis and on the basis of humanity, and I have spoken to my colleague from the DPP, as we welcome the ruling, I am making an application to review one term, just one, on the cash bail. I am proposing this. I am making a proposition that because it is a new year, Your Honor, you do review the cash bail term to a personal bond, or because we are all officers of the court, you review it to 1,000, which I shall pay personally as an officer of the court to secure their release today, so that on the day that the court will order they come back, we will come back on that day. 5,000 for most of them, if not all. I believe the good senator also has not seen his parliamentary service fund. He will not be able to get out of it. So even for the senator, I will pay the 1,000 for him. I am asking on humanitarian grounds that you do review the cash bill, and all of them may be sick. Just 1,000. My good colleague from the PDP, I have spoken to him, is also a man of God. He says that he does not see the challenge in the review. Just that. Just that.
May I chip in, Your Honor? Honor, we can't do it. But as my other friend has said, we are all even millionaires a long time ago are now pauper. I don't have 5,000 shekels. I have to tell you the truth as a Christian, I do not have 5,000 shekels. Honor, wave the cash there. Let these young people, they are poor people, let them go and join their families and celebrate the new year with their families. They will stay here. No one wants to leave Kenya. Kenya is the most beautiful country in the world. Being spoiled by the regime. Yeah. Thank you. My friend has put a right that it is appropriate. It's the most beautiful country, except we have for a long time lacked property.
As a man of God.
Your Honor, we hear that word very much in the
He means it.
Your Honor, there was the court that so we run the report that is not the agreement. And also, whatever amount you put, that there will also be a right that there will be a contact person. For each and every 22 of them for the attendance.
There is a senior counsel.
I don't want senior counsel to be taken for
No, if
contempt.
we say contact person, it will complicate, and with the time remaining, they will not be free.
Yes. Yeah.
I offer to be the contact person for the 20.
Thank you very much, Madam. Yeah, thank you very much.
So you have seen the DPP has not opposed the limit to 1,000.
No, I did not say the amount.
I already have it on M-Pesa. Anytime the court directs, you just throw it to case. We walk out with our fellow brothers.
Freedom fighters. This president is still receiving. That's not his passport. The very fact that they have put some of us who are here in this courtroom means that they are already receiving. If they don't obey the court order, I will definitely not come to the court. The very fact that they have put me here, it means that they put Martha, our former minister of justice, it means that they are people with compliant the court. The young people, poverty stricken, hungry,
and broke,
and drugs.
Okay, I don't know about that.
Your Honor, one word. Permit me to my colleague Kafafai, wish you a happy and prosperous New Year.
Honor, before you get honor, will humbly tell to make an application because they have mobile phones and personal belongings. The restaurant.
I would allow our senior to close once. And wish the court has
Dr. Kabelo has already record Happy New Year. And all the court attendees and all those present, including we no longer need a contact person. You did not put that condition. Yes, we'll be present.
Happy New Year, Honor. Happy New Year, happy birthday.
Ilete baraka kwetu, akiwe ngao na mlinzi, na tukae na uhuru, amani na uhuru, raha tupate na ustawi. Amkeni ndugu zetu, tufanye sote bidii, nasi tujitoe kwa nguvu, nchi yetu ya Kenya tunayoipenda, tuwe tayari kuilinda, na tujenge taifa letu, ndio wajibu wetu. Kenya istahili heshima, tuungane mikono pamoja kazini, kila siku tuwe na shukrani. Comrades, power! Viva! Sana toa roho yangu, freedom!
freedom.
Freedom, freedom.
Freedom now, freedom.
Freedom, freedom.
Now, freedom.
Freedom.
Freedom now, freedom.
Freedom.
Viva, viva, viva.
Viva.
Viva, viva, viva.
Viva.
Kasongo down, Kasongo.
Kasongo, hey. Mobali na gari. Kasongo, hey. Chapati za Christmas. Precious. Chapati za Christmas. Viva! 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 Hakuna mwizi kama Ruto. Hakuna mwizi kama Ruto. Hakuna mwizi tumesoma katiba. Kufanya maandamano ni haki yetu, kulingana na polisi ni haki yetu.
Napatia serikali wa kule KFC, sisi wajenzi tunataka KFC. Wacha Kimani Uchunga aseme. Kimani Uchunga tumepatia 1000 ya KFC. Ujue tuko na pesa. Unaongea kwani?
Sawa.
Kama unasema kuja
Hanifa.
Nina?
Hanifa. Hanifa, Shakira. Shakira, Hanifa.
Lete. Sawa.
Tutashikia mic. Tutashikia. Tutashikia. Tutashikia mic.
Plug make sure sound ina na control sound vizuri.
Ni mingi sana kusaidia zingi. Kuna mwingine atakusaidia? Ni mingi. Na nashika simu. Just shut us. Just shut us. Ready?
I shall be very pleased because I've got a new engagement. Mine was here just now. He has a sense of fairness. He has a sense of justice. And that's what we need. Those of you who are young may not know that very much about the history of this country. This country is where it is because of the judiciary. We have had judiciary on the whole. In recent times, one can say has been strong, has been independent, and we should continue to support it. Without the judiciary, without a strong rule of law in the country, we would probably not be where we are at the moment. We still feel that we should have hope, continue to have hope in the judiciary. And this magistrate has shown us what it is, that as we start the new year, we should proceed united and make sure that the rule of law in the country is upheld. It is unfortunate that the conduct and behavior of what is going on, our young men or young women disappearing from the country, is disgraceful and despicable. No wonder that some individuals have decided to go to The Hague and file a suit there because of what happened. People just disappearing in the country is something that happens in our country that one can refer to as a banana republic. Kenya is a mature country, and we continue to feel that we are a mature country. Let those who are behind disappearances learn and listen and stop abducting young people and doing all sorts of lessons in their lives. Thank you very much.
Well, my name is Patrick. And a couple of things
kwa sababu ndio kuna history ya kila kitu.
innocent, but what is right and what is easy. It should be encouraged, but there should be the norm each and every day. Frustrated candidates are actually fight for their own rights. Equally, as much as they and for Bernard as well, Peter, all those candidates who are abducted, to be released without they can't join the families, because it's quite disheartening that we are trying to roll back, from where we once tried to run away from. So abductions, arbitrary arrest, equally should not be encouraged. So we are happy that they have been released today, those who are arrested, and we thank the Law Society of Kenya for always standing firm, for always standing true to its call to protect, safeguard, and defend the rule of law. So with me, the Vice President of the Law Society of Kenya, Mr. Mora Kabata, I would just invite him to say a word or two. Thank you.
Tumefurahi kama jamii ya mawakili kupata hawa mandugu zetu 23 wamepatiwa uhuru wao mahakamani kwa shutuma za polisi ambazo sio za halali kwetu sisi. Tumezidi kuendeleza ama kuhimiza mahakama kwamba mambo haya ya serikali ambayo sisi hatuambatani nayo ama hatuelewani nayo, ni kwamba wananchi wana haki za kuungana, kuandamana na kufanya maandamano ya amani, na kwamba njia yoyote ambayo sio ya kisheria ya kuuzilia mbali haki hizi, sisi kama jamii ya mawakili tutasimama kidete, tutahakikisha kwamba sheria ya kikatiba na wala sio sheria ya kiimla ndio itakuwa inafuatwa. Tumefurahi kwa sababu leo kipindi cha mwisho, siku ya mwisho ya mwaka huu wa 2024 tumepata maelekezo thabiti ya kisheria na ya kikatiba, na kwamba hawa mandugu zetu 23 leo watajumuika na familia zao, watafurahia mwaka mpya wakiwa huru. Alafu tutarudi tarehe 21 kuja kufanya ama kuchukua maelekezo mengine kotini. Lakini tunahimiza kwamba kuna utekaji nyara, mfumo wa kuteka nyara wa Kenya ambao unaendelea, mfumo ambao sio wa kisheria bali ni mfumo wa kigaidi. Yani tunasema kwamba kuna watu katika serikali ambao wamechukua sheria mikononi mwao na wanaangamiza misingi ya kikatiba, misingi ya kidemokrasia ambayo sisi kama Wakenya tumepigania muda mrefu. Lakini haimaanishi kwamba tulipopigana tuliweka silaha zetu chini. Silaha bado tuko nazo, silaha za amani, silaha za maridhiano, silaha za kuhakikisha ama kudhibitisha kwamba nchi yetu ya Kenya haitarudi katika mfumo wa kiimla, mfumo wa kibepari. Tunasema kwamba sisi kama mawakili tuko tayari kuanzisha mfumo mpya wa kidemokrasia, wa kisheria. Na sisi kiapo chetu kama mawakili, wote hawa walio hapa ni mawakili wanachama wa Law Society of Kenya, tulichukua kiapo kwamba tutachukua sheria, tutalinda sheria, tutalinda katiba na tutafata mfumo ambao ni wa kikatiba. Tumefurahi leo kwa sababu tumeona afueni, koti imeimarisha udhibiti wa sheria kwa kusema kwamba waandamanaji hawa wa amani wapatiwe ruhusa wale watakapolipa bail ya shilingi 1,000 kila mmoja wao, ambao inalipwa sasa hivi. Kwa hivyo muda usio mrefu watatoka wakiwa huru na mnaweza kuwahoji. Lakini nawashukuru wenzangu hapa kwa sababu tumeshinda hapa siku nzima, labda wengine hawaja kula, mimi nilikuwa nimekula. Nataka pia nyinyi wanahabari niwaombee muwe na siku njema, mwaka mpya wa fanaka na baraka. Tutaonana mwakani pia. Asanteni sana.
Senator.
Yes. Let me say that today justice has been seen in the courts, and we want to say that the courts are the last defense for the people of Kenya. There were no offenses committed as such. The affidavit of the police officer did not disclose the offense. But I want to urge young people that the biggest battle is on the courts. And we want to urge those who are 18 and have no IDs to get their ID cards. Then go to the constituency IBC office. Is open, is operational, even if there are no commissioners, and register as a voter. That is the best weapon you can have to create change in the country. Without that, we are going to have this problem. Let all the young people be on the deciding table in the next election. And I urge the country to have IBC as quickly as possible. We have lost members of parliament, and the places have not been replaced. The abductions are outrageous. We know that state agencies are guilty of this. There's no one else licensed to have handcuffs other than a state officer. There's no one licensed to have a gun. And even nowadays they have guns to shoot the vehicles of those they want to abduct. to follow up, and even vehicles hanging around tracing people to be abducted. We also want to call upon Kenyans to rein on such people, such abductors, now that the government has denied they belong to them. When you see somebody hanging around as they did in Embu, 2-3 days, number plate with fake numbers, when you search them, they appear to other people. Let the wananchi also help do public arrest on these people so that we can hand over them to the police. And we want the IG to obey court order. Let him come here in court. Either bring these people, he has capacity to arrest these criminals. He knows who these criminals are. Let the IG give orders and arrest the criminals, whether they belong to state agents or whether it is even the director of CID or people, CID officers if they are involved. Therefore, let the rule of law rule this country, and next week we expect the IG in court and we expect the abductees to be released.
Okay, now, just a moment.
Mr. Wamala Paul Jr., this is my piece of advice to our President, His Excellency Dr. William Samoei Ruto. Kenya is our country. We cannot run anywhere. This country needs a lot of wisdom in leading it. That's a need for us. Another thing, His Excellency, he took an initiative on 11th of July 2024 by dismissing all of the cabinet secretaries. But he forgot only one thing, to dismiss all friends of him surrounding him. All friends of him surrounding him, because they are misleading him, they are not helping him. We want peace in the Republic of Kenya. This is our country. The economic status of our country and the political status, when we look at it now, it's not good actually. Where shall we run to? The image of our country, some years back they were calling Kenya as a country of peace, as a country that most of people really loved it. But at this particular time now, when you look at our country, actually, it is in a very dilapidated state. Therefore, at this particular time, I wish also to give my appreciation to the entire court for the arbitration that they did so that they can be able to release these freedom fighters, mainly to go and celebrate the new year at their home. Otherwise, let me wish you best of luck, the social media for the work that you have done, and may the Lord bless you abundantly. New year of 2025. Thank you very much.
Hello everyone. We want first of all to say thank you for being here the whole day. It's been a long night and another day we're here. We want to say thank you so much to every lawyer that has been there in Gigiri, in Central Police, even in Kamukonji. The phone calls, every legal help that you've gotten, we want to say thank you very much. And I would even mention Mother Karua Advocate, Dan Maanzo, Advocate Kaminwa, Advocate Ndegwanjiru, and all the others. We want really to say thank you. We are the Presidential Exploratory Committee of the presidential ticket of Okia Omtata, and we had to do this because, of course, we still do not know where the abductees are, and that's the reason we went to the street, and that's the reason we're here. We want to say categorically that they really hurt him. It has a lot of pain, so after this, we are actually headed to the hospital. He's not okay. He was not able to have his medicine, good part of yesterday night. He got his medicines late. He's not doing very well. So I just want to tell Kenyans to keep us in their prayers. After this, we are headed to Nairobi Hospital to admit him for checkups because there are a lot of things that have not gone right since yesterday. But we also want to give our thanks to Kenyans, well-wishers, friends, journalists, everyone who has held vigil with us and are here. Let's keep fighting. This is a long fight and we have to keep doing it, and more so until the abductees have been found. because until now we do not know where they are. But we are trusting we are going to get the abductees, and I'm going to allow communications director in the PEC committee to say something.
So thank you so much. For me, it's just to thank the fourth estate. I think you guys were with us the whole of yesterday from the time Senator was arrested to Gigiri, and I remember when we started following the police cars from Gigiri to Pangani to Kamkunji, the press was with us. So it's just from us, from a Presidential Exploratory Committee, is to say thank you so much to the journalists. I think you guys have done a remarkable story to tell the country what is happening and what Senator is doing. Apart from that, I think for us, as you have said, we're not going to rest. The Senator has said that he'll continue following up until all the abducted Gen Zs are found. I think it's something that he holds dear in his heart, and it's something that he'll follow up. And I think moving on from next, once he's released, we're taking him to hospital for him to be checked up. After his checkup, I think he'll go back to his duties and try and find out where they are. So thank you so much, and we really appreciate what you guys have done for us. Thank you.
Sasa,